People of the State of Michigan versus Donald Raymond Lester. We are here today for a final pretrial conference in this case ahead of a trial scheduled for June 20th and 21st. We are proceeding today partially in person and partially by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure filling in for prosecutor of record Isaac Sneed.
Samara Hennigan on behalf of Donald Lester.
All right, and Mr. Lester, I believe, is in the jail Zoom 2 device. Mr. Lester, are you there?
Yeah, I'm here.
All right, so I don't know what's going on with the camera. We can't see you. It looks to be
I can see you.
Almost. I'm saying that we can't see you, Mr. Lester. So, Ms. Hennigan, where do we stand? Are we ready to proceed to trial on June 20th?
Thank you, Your Honor. I met with my client yesterday and did make the final offer to him with regard to plea agreements. My client has declined to accept the plea that was offered by prosecution. I also was informed by my client that he has filed a few motions. I guess you would say pro se. I have not seen those motions myself, but he says he mailed them to the court. He does have many objections to the proceedings. That being said, the next step that would be appropriate with regard to our legal procedures would be to go forward with trial. I am prepared to do that, though I do believe that my client will object to that, Your Honor. So I do want to make sure that I represent his wishes as well, while I still inform the court of whether or not I'm ready to proceed. So I will be ready to proceed for trial next week. That being said, my client does not want to go to trial as he feels that the court doesn't have jurisdiction over him on this matter in order for us to move to trial.
Hey everyone, welcome back to the channel. Today's video brings back a familiar face, a self-proclaimed sovereign citizen I covered not long ago. You may remember him as the one who couldn't stop talking in court and ended up earning himself 93 days behind bars for contempt. This time, we're picking things up at his final pretrial conference. The stakes are high, but surprisingly, the court offers him a very generous plea deal. It's the kind of deal that could let him walk out of jail immediately. However, there's one simple condition standing in his way. He has to stay calm, listen carefully, and resist the urge to argue. Whether he can control himself long enough to secure his freedom is the real question. Let's get into it.
He was very upset. I would add, just for the record, for his for appellate purposes for him, that he was upset that I agreed to a trial schedule at a past hearing. And I did try to explain to him that that's just a procedure, that the court is on timeframes according to statute, and that at some point we do have to set a trial schedule, even though it was my intent to continue to try to negotiate this case for him along the way.
All right, to the extent that there's any objection based on court's jurisdiction,
I can't hear you. Can you speak up, please?
To the extent that there's any objection to proceeding to trial based on the court's jurisdiction, I would deny that, as the court does have jurisdiction over this case. It is a felony case involving an alleged felony which is alleged to have occurred within Lenawee County, state of Michigan. This is the circuit court for the Lenawee County, state of Michigan, and therefore jurisdiction is appropriate. Ms. McClure, is there anything we need to address from the people's side?
The people have not received any motions that have been referenced, but as far as I know, we are prepared to proceed to trial next week as well.
Right.
All right, so do we have proposed jury instructions and voir dire questions yet?
We do not. I know I spoke with Mr. Sneed yesterday, but I'm certain that we can agree upon those within the next day or so.
I see some in our file, so maybe he's drafted them and just not.
Yes. He was working on them.
Okay, so I'll need those by the end of the week so that we have an adequate amount of time to get prepared
Right.
for trial.
I would also like to intervene here real quick, but that being said, the motion is just not for the jurisdiction, it's also for personal jurisdiction and subject matter jurisdiction. I had the right to a resisting unlawful arrest, and it's not being addressed. The Supreme Court ruling on that, I just read that not too long ago, and they arrested me for an old traffic ticket, is where it started at. They're trying to dodge the point of where they harassed me for 3 days before they arrested. And as far as this possession situation go, I was informed yesterday by my attorney, who I haven't talked to since March, that I was looking at 14 years. Under your court, Michigan rules, that after 10 years, under a lower felony, after 10 years, it's automatically expunged. So I'm trying to figure out how am I being charged with a habitual criminal. And also, I would like to get that in writing, that you said that you have jurisdiction over this case, but not the said person.
As expected, he fails to do that. From his point of view, and from the broader sovereign citizen mindset, the belief seems to be that rules simply don't apply to them. In their world, they think they can break laws freely as long as they personally decide no harm was done. That idea completely ignores how society actually functions. Laws aren't optional, and they don't disappear because someone claims a special status or personal interpretation. Order exists because everyone agrees to follow shared rules, even when they don't like them. We live in a structured society, not chaos. Courts, statutes, and consequences apply equally to everyone who steps into that system. No matter what label someone gives themselves, they are still expected to follow the same laws and standards as everyone else.
And that's all in the motions that I sent over to the clerk's office. I also have them all notarized. I also have copies of everything that I sent over there. So there should be somewhere in y'all file that y'all should have it.
Your Honor, I did.
And personal. And like I said, I haven't talked to this woman since March. She told me that I was going to be released out for bond, and I haven't heard anything from her since then. I wrote her a letter. The first time I seen this woman in about 2 or 3 months, his first time was yesterday. And she doesn't represent the said name anyway. I've talked to her about that situation too. Somebody's not being truthful here. And I've been sitting here almost 10 months without a bond or even so much as calling my witnesses. She's never asked me anything. So my due process is being violated. Also, I'm sitting in here on an unsigned warrant. Unsigned. A probable cause warrant. They trying to make it look like they arrested me for those charges, and it's not what it was for. That's not what it was for. I was arrested for driving on a suspended license from back in 2016. That case got dismissed.
Your Honor, I did inform him
He's not
yesterday.
addressing none of those issues, Your Honor. Period.
Mr. Lester, I need you to stop interrupting people, okay? What is it that you wanted to say?
I did inform him yesterday that the charges he was facing could, that it's up to 14 years because there's consecutive sentencing available on those charges. He has a felony that is up to 10 years and then 2 R&Os which can be sentenced consecutively if that were requested and or if the court were to do it. And I informed him of that at the time that I was telling him about the plea agreement that would allow him to be released today.
He is under no obligation to hand over written proof of the court's authority to him or to anyone else. That question was already settled long before this hearing even began. The moment he was brought into custody and appeared before the judge, the court's jurisdiction was firmly established. This isn't some abstract concept that needs to be debated line by line. It becomes clear through the reality of the situation itself. Waking up in a detention facility, under lawful custody, is a clear indication that the legal system is already in effect. Jurisdiction isn't something a defendant gets to opt into or challenge simply by demanding paperwork. It exists because the court has lawful authority over the case, the person, and the charges involved. Whether he accepts that fact or not doesn't change the reality in front of him.
So he is correct in that I did inform him of that, but it's not because of a habitual offender notice. And he asked me about that yesterday, and I reiterated again yesterday that that is not why. That is not why he's facing that amount of time. It was simply me telling him worst case scenario in this matter.
All right, so to the extent that personal jurisdiction issue has been raised in addition to subject matter jurisdiction, and again, deny any request on those bases because the court, again, has personal jurisdiction over Mr. Lester, who is a human being located in Lenawee County, Michigan, and alleged to have commit a felony crime in Lenawee County, Michigan.
How did I commit a violent crime?
With respect to the argument that Mr. Lester made regarding the right to resist an unlawful arrest, that's why the court is having a trial. One of the elements that the prosecutor needs to prove in a resisting and obstructing case is that the officers were on duty, acting lawfully, and made a lawful arrest that Mr. Lester resisted. So that's the purpose of the trial. With respect to any issue about expunged convictions, we're not even to that point yet. The habitual offender issue comes into play only after a conviction has entered, and then the court has to determine whether the convictions listed in the habitual offender notice in fact happen and can appropriately be used under the statute for the sentencing enhancements that have been notified in the information. And so
okay, so
whenever
you get done, I'd like to address the issue too, please.
All right, I'm going to mute Mr. Lester because I can't have people talking over me while I'm trying to create a record. All right, so then we are ready to proceed to trial on June 20th. Again, I'd like to have the voir dire questions and jury instructions ready or to the court by the end of the week so that we can have those ready to go.
Thank you, Your Honor.
Yeah. Before we go,
Ms. McClure, can I just understand from you what that final offer you made on this case, or what the final offer the prosecution made on this case was?
Yes, it would be.
Ms. McClure, I actually have a copy that I could pass to the court too, if that's okay with you.
Yeah, I mean, we'll just take a second. It's an added count for possession of meth in a park, which is a 2-year offense. And we were offering credit for time served, which is approximately 10 months. And we have no objection to a PR bond at the time the plea is taken.
Well, this turn of events is hardly shocking. Here he is, reacting with outrage over a possible maximum sentence of 14 years in prison, even though there's a plea deal sitting right in front of him that could have him released the very same day. That contrast says everything. One path leads straight back into the community, while the other risks years behind bars. Yet instead of focusing on the opportunity he's been given, he fixates on worst-case scenarios and lets emotion take over. Some viewers may feel sympathy for him, and that reaction is understandable. But the reality is, he's clearly intelligent enough to grasp what's happening. He knows the consequences, he understands the stakes, and is making these choices fully aware of how costly they could be.
The prosecution has made an offer to resolve the case if Mr. Lester were willing to plead guilty to possession of methamphetamine in a park. That's a 2-year maximum possible penalty, but the prosecution has also agreed to credit for time served or fines and costs and a personal recognizance bond release until the date of the sentencing. Is that all accurate, Ms. McClure?
How is that? That
Yes.
is crazy.
Yes,
All
that's
right.
accurate, Your Honor.
And Mr. Lester is not interested in agreeing to that plea. Is that correct?
It's my understanding, but it seems that he would like to say something about it, Your Honor, so I prefer that he answer that question himself.
Yeah, I would like to say something because of the fact that you keep trying to let me out on a PR bond and you want me to come back to court for sentencing, but you won't let me out to try to get my witnesses and gather the evidence that I need to be able to present it at trial. I haven't even went over this woman. I haven't even went over any kind of defense with this woman. I am being prosecuted and persecuted by her and a prosecutor. And it's obvious. It's very obvious. It stands out. I haven't talked to this lady since March. And when I did, she came in there and coerced me into trying to keep her on my case.
That really is an incredibly generous plea deal. What started as exposure to a possible 14-year prison sentence is reduced all the way down to time already saved. With the case wrapped up and no further consequences hanging over him, even more striking is how little is being asked of him in return. He isn't required to make a public apology or explain himself at length. All he has to do is acknowledge what happened and accept responsibility for it. But that's the turning point where everything falls apart. If he were willing to simply say, "Yes, I did it," this entire situation would already be over. And honestly, if he had taken that simple step, none of us would be here watching this unfold today.
So, Mr. Lester, that wasn't really responsive to the question that was asked. The question you're being asked
I don't know
right
nothing
now.
about that. I told her what it was then, and
Mr. Lester,
you keep trying to cut me off.
well, that's because you won't let me create the
Right.
record and do my job. So I'm
I'm
trying
trying to do my
get-
job. You're not the one sitting in jail, sir.
Your Honor, would
All
you
right,
please
so-
mute my client? I don't want him to.
Record
Find
should
yourself in
reflect that. The record should reflect that Mr. Lester had, I'm sorry, so. Mr. Lester, the question I'm asking and that I need an answer to is, you've heard the offer that I've indicated the prosecution has made to you to resolve the case. Do you or do you not want to?
No, I'm not, because they had no business arresting me, Your Honor. And that I wasn't
No,
bothering
no,
anybody.
A simple no is fine. That's all I needed. All I needed was no.
Quit talking to me like I'm a kid.
Listen to how unreasonable this sounds. The judge isn't dismissing your case just to target you personally or make your life harder. You're not the only indigent defendant in the system, and you're certainly not your attorney's only client. Public defenders juggle heavy caseloads every single day. They can't visit one person constantly or give nonstop personal attention, no matter how important that case feels to the individual involved. That isn't neglect, it's how an overloaded system functions. And here's the uncomfortable truth. If anyone is damaging this situation, it isn't the court, the judge, or the defense attorney. The biggest obstacle here is his own behavior. Every interruption, every refusal to cooperate, and every bad decision is coming directly from him.
Answer is no, so we will proceed to trial next week. I don't think there's anything else we need to address this morning. So Mr.
Bond.
Lester,
I need a
let the
bond.
officer know.
What are you even arguing about at this point? The court offered you a bond, and you flat out refused it. That's not a system failure or someone else mistreating you. That's a decision you made yourself. When a solution is offered and you reject it, the consequences fall squarely on you. And with that, we've reached the end of today's video. Based on how this hearing wrapped up, he'll be back in court next week. Instead of walking out of jail today with this matter fully resolved, he's now facing the very real possibility of up to 14 years in prison. All of this could have been avoided with a few simple choices. But once again, we see how self-defeating strategies and misguided confidence can turn a clear exit into a dead end. Risking your future on arguments that go nowhere is becoming a familiar pattern in these cases. That if you found this video informative, go ahead and hit the like button. If you didn't, feel free to hit dislike. Either way, let your thoughts be heard in the comments below. Don't forget to subscribe and turn on notifications so you don't miss upcoming updates. I'm Team Skeptic, and I'll see you next time.